Welcome to the Judicial Committee of the Privy Council, where today we're beginning the second day of hearing two appeals from the British Virgin Islands concerned with the granting of what are called freezing orders. We're currently hearing submissions on behalf of the first respondent to the appeals, presented by Mr. Richard Morgan, Queen's Counsel. So I'll turn now to Mr. Morgan.
My Lord, I'm grateful. Before the adjournment, I was making submissions about the separate corporate personality of the first respondent and the need for there to be a case asserting some right to its property. Starting at the first level, in order to justify a freezing order to deprive a person of their fundamental right to the free use of their own property, an applicant must demonstrate a number of things, not the least of which is an existing substantive right against that person. If a freezing order is sought against a third party, allegedly parasitic on a freezing order against a primary defendant, then the applicant needs to go further. It needs to identify what right is said to be exercisable by the primary defendant against the third party, and articulate clearly the evidential basis to support the allegation that the third party's assets could be available in satisfaction of any liability of the principal defendant. Before Justice Adderley, CCL initially had no injunction against Dr. Cho, although an injunction was reimposed at the start of the hearing by an application to the Court of Appeal. It had no right against Broad Idea. It had not articulated any case to Broad Idea's assets, either by it or by Dr. Cho, and there was no evidence to support any case, even if it had been articulated. Further, the injunction that it did obtain gave CCL rights in relation to Broad Idea's assets that Dr. Cho himself did not possess. How, one asks, could CCL obtain, on execution of a judgment against Dr. Cho, a better right to Broad Idea's assets than that enjoyed by Dr. Cho? The answer is that it could not, and it should not have been granted an injunction looking directly into Broad Idea's assets and at Mr. Choi's shareholding. Even assuming for the moment that CCL had a justiciable claim against Dr. Cho in the BVI and had joined Broad Idea as a Chabra defendant, unless it could articulate an intelligible case to be entitled to specific assets, in which case those assets could be frozen, its relief ought to be limited to Dr. Cho's interest in Broad Idea's shares, and an injunction in identical terms to that obtained in Hong Kong would have the identical effect. That injunction would have been directed against Dr. Cho and not against Broad Idea. The whole purpose of pursuing this appeal, the whole purpose of CCL pursuing this appeal, is illustrated by this point. CCL has no further interest in addressing Dr. Cho's position, which is secured by the Hong Kong injunction. Instead, this is all about prejudicing the interests of Mr. Choi, said by Forbes' list of Hong Kong billionaires 2019 to be the 10th wealthiest billionaire in Hong Kong, and you see that at paragraph 56 on page 2557 of Mr. Choi's second affidavit, and by material exhibited to Mr. Yap's own fifth affirmation at YEH 5 on page 6381, to be worth approximately 4.8 billion US dollars. CCL and its parent want to exert pressure on Mr. Choi, but there's no conceivable way that they could ever obtain a freezing order against him in Hong Kong, both because they have no good arguable case and because they could not quantify any financial sum to which either Convoy Global Holdings Limited or CCL could be entitled, and because there's no risk of dissipation or secretion of assets by Mr. Choi, who is both well known and massively wealthy. Instead, they have chosen to achieve that pressure through the back door by freezing Broad Ideas assets and attempting to impede the free exercise of Mr. Choi's entitlement to deal with Broad Ideas shares. So much is confirmed by the fact that when in December 2018, Broad Idea and Mr. Choi proposed a way for Mr. Choi to be extricated from the picture by Broad Idea repurchasing his shares, although CCL initially consented and the court permitted Broad Idea to vary its undertaking to allow that to occur, CCL subsequently withdrew its consent and issued its notice of application seeking to extend the injunction to all the shares in Broad Idea. It is that notice of application which gives rise to this appeal. That concludes the submissions on my second point. If I may, I'll move on to my third point, which is that the existence of a claim justiciable in the BVI asserting a right to have access to Broad Ideas assets is a threshold requirement for obtaining an injunction against it. My Lords, at page 13479, you find Section 24 of the Eastern Caribbean Supreme Court Act 1969. The power to grant an injunction is contained within that section, and it's, in familiar words, a mandamus or an injunction may be granted or a receiver appointed by an interlocutory order of the High Court or of a judge thereof, in all cases in which it appears to the court or judge to be just or convenient that the order should be made. And any such order may be made either unconditionally or upon such terms and conditions as the court or judge thinks just. And then reading on, you'll see that the wording follows or addresses the case of apprehended waste or trespass. Now, rather than following Section 45 of the Supreme Court Judicature Consolidation Act 1925, Section 24, in fact, tracks the wording of the earlier Section 25, subsection 8 of the Judicature Act 1873 at page 141376, if you wish to compare the wording. But it tracks it through. Since the wording of the 1873 Act and the broadly similar wording of the 1925 Act have been considered by the English House of Lords and the Privy Council, the BVI courts should regard themselves as bound by those decisions on the same or equivalent wording. And for these purposes, Broad Idea relies on the advice to Her Majesty given by Lord Diplock in De La Sala and De La Sala, and the relevant passages at page 10409C to F. Summarising it briefly, whilst it's technically correct that as a matter of jurisprudential analysis, those decisions are not binding, given that it's an interpretation of an English statute, and it's the meaning of the words of the English statute, it may be that in juristic theory it would be more correct to say that the authority of its decisions on any question of law, even the interpretation of recent common legislation, can be persuasive only, but looked at realistically, its decisions on such a question will have the same practical effect as if they were strictly binding, and that's because of the identical wording. The language used is the same language, it's English. The words used are susceptible to the same process of interpretation. The meaning should be the same. It should be independent of which court or tribunal is considering it. So what do those House of Lords cases say? If I may, I'll start with Lord Diplock in the Siskina, a passage to which the board has already been taken, at page 12831 at C to F. And there he says, nevertheless, I do not think that the instant appeal provides an appropriate vehicle to carry your lordships into a consideration of the wider question of what restrictions, whether discretional or jurisdictional, there may be upon the powers conferred upon the High Court by Section 45(1) of the Supreme Court of Judicature Consolidation Act to grant a mandamus or an injunction or appoint a receiver by an interlocutory order in all cases which it appears to the court to be just or convenient so to do. That subsection, speaking as it does of interlocutory orders, presupposes the existence of an action, actual or potential, claiming substantive relief which the High Court has jurisdiction to grant, and to which the interlocutory orders referred to are but ancillary. This factor has been present in all previous cases in which moravian injunctions have been granted. As the ship owners contend, and Mr. Justice Carr and Lord Justice Bridge held, it is not present in the instant case. The general rule is that the jurisdiction of the English court over persons is territorial. It is restricted to those upon whom its process can be served within the territorial limits of England and Wales. Going back to look at the wording of section 24 on page 13479, for an injunction to be granted, there needs to be a case in which it appears to the court or the judge to be just or convenient to grant the order, and the order can only be interlocutory. There are 2 points on the wording. First, the power is only exercisable to grant an interlocutory injunction. To grant a final injunction requires a trial. To what is the injunction interlocutory, though? The answer must be the trial of the case. Secondly, the test of just or convenient is to be judged by reference to that case. So again, there has to be a case that's going to go to trial. This textual analysis resonates with the common endorsement thereafter of the passage from the judgment of Lord Justice Cotton in North London Railway.
Before we get to that,
of course,
Lord Leggett has a question.
So I do beg your pardon. Yes.
Mr. Morgan, how on that analysis do you explain a post-judgment freezing order, which very shortly after the Siskina, Mr. Justice Goff decided could be granted, even though there had been no freezing order before the trial?
Well,
You say that it can only be granted when there's a pending trial on that basis. The post-judgment freezing orders, let alone all the other.
No, my lord, no, I'm not saying that. Well, I'm saying that there are 2 distinct regimes. There's a pre-judgment regime where the applicant relies on the Section 37 power in England and Wales or Section 24 in the British Virgin Islands, and there's a post-judgment regime where the court has reached a determination on the merits and grants final relief in whatever form that it considers just. So
it's not a final order in the sense that it lasts forever. It's just pending execution of the judgment.
Well, my lord, yes,
in aid of enforcement.
It is granted in aid of enforcement, but the form of the order is final. It's not susceptible to challenge, and it's only susceptible to challenge insofar as the judgment itself is satisfied. So there's no conditionality about its grant. The only conditionality is in the amount that it restrains the defendant or the respondent from dealing with.
Well, why can't you exercise that jurisdiction before judgment, if that's the basis for it, and implement the principle that Lord Nichols articulated and others, that the aim of it is to make the judgment enforceable, if you get one.
Because with respect, my lord, the right to the sum, to receive the sum has been determined finally. It is part of the exercise of the court's jurisdiction following the final determination of the rights. Section 37 and its predecessors says nothing about the rights of the court to grant final injunctions. And the power that's relied on here is the right to grant injunctions, or the ability, the power of the court to grant injunctions before it's determined the substantive merits.
But it's open to that to the objection. It's not attempting to enforce the substantive merits. It's just attempting to protect the position if you get a judgment to make sure you can enforce it.
But it's conditional upon obtaining the judgment. There must be some route to determine whether the injunction is properly granted or not, pre-determination of the case. After determination of the case, that conditionality is no longer necessary because the merits have been determined. There is a final order adjudging the defendant liable to the claimant, and the injunction is protecting that very judgment. It's a final injunction. It's like pre-1873, a writ of injunction was a final order. The practice in the Chancery Division was to be able, or the Courts of Equity, was to be able to grant an injunction before that final adjudication. So, in my respectful submission, this section says nothing about the powers of the court to grant injunctions post-judgment. So, if I may, I'd like to go back to the fact that the textual analysis resonates with the common endorsement of the passages from the judgment of Lord Justice Cotton in North London Railway, as enunciated by Lord Diplock in the Siskina at 12833, E to G. Since the transfer to the Supreme Court of Judicature of all the jurisdiction previously exercised by the Court of Chancery and the Courts of Common Law, the power of the High Court to grant interlocutory injunctions has been regulated by statute. That the High Court has no power to grant an interlocutory injunction except in protection or assertion of some legal or equitable right, which it has jurisdiction to enforce by final judgment, was first laid down in the classic judgment of Lord Justice Cotton in North London Railway, which has been consistently followed ever since. Implicit in this is the fact that the right had to be the subject of the case proceeding before the court. For as Lord Diplock said in Gourier and Union of Post Office Workers at 10873, D to F, the only kind of rights with which courts of justice are concerned are legal rights. And a court of civil jurisdiction is concerned with legal rights only when the aid of the court is invoked by one party claiming a right against another party to protect or enforce the right, or to provide a remedy against that other party for infringement of it, or is invoked by either party to settle a dispute between them as to the existence or nature of the right claimed. So for the court to have jurisdiction to declare any legal right, it must be one which is claimed by one of the parties as enforceable against an adverse party to the litigation, either as a subsisting right or as one which may come into existence in the future conditionally on the happening of an event. The essential prerequisite for an injunction is therefore that there is before the court a substantive claim in which a claimant seeks to vindicate a right, legal or equitable, against the defendant.
Mr. Morgan, there are obviously several categories of injunction which are common in practice that one can think of that don't fit that model. Are you going to come on to deal with them? I'm thinking of anti-suit injunctions, injunctions restraining insolvency proceedings, Norwich Pharmacal orders. Are you going to come on to deal with them?
My Lord, first, and without wishing in any way to dismiss your Lordship's, the depth of your Lordship's question, we have attempted to deal with all of that category of cases in Appendix 3 of our written case. Yep. Second, as regards Norwich Pharmacal orders, they result in a final order rather than an interlocutory order, and they are based upon a right in equity. Anti-suit injunctions, and again, without wishing to embark upon too grand an analysis and attempt to rationalise the entirety of equity in the short time that I have available, again, in my respectful submission, are based on the recognition by the courts of an equity to prevent interference with the right of the applicant to have its case adjudicated upon before the court of the appropriate jurisdiction. So, looked at as a diffuse body of authority, one can say that there are categories of cases that are not obviously or immediately four square within the way that Lord Diplock enunciated the position in the 1970s. However, it's my submission that if one really sits down and picks away at the problems, that one can generally find a legal or an equitable right that the court is protecting, that actually exists at the time that the issue is raised before the court.
And yeah, so just thinking about the comparison between the freezing order and the anti-suit injunction, why can one not say that the freezing order is granted in recognition of an equity to prevent the avoidance of enforcement proceedings, enforcement of a judgment?
Well, my lord, one could articulate it like that, but what I've tried to do in the structure of my argument is to show that the essential prerequisite is the right against the primary defendant to recover damages. And in going to Cardilli and showing your lordships the test in Cardilli, the right has got to flow through. It might not be the right to recover the damages under the initial cause of action, but there's got to be some intelligible way to show that entitlement to damages, entitlement to have a judgment that's recoverable, flows through into the assets of the non-cause of action defendant.
Oh yes, well I see that. If I may say so, that's the point you dealt with under point 2, isn't it?
Yeah, my lord, yes, but
I don't see how you can rely on Cardilli to help you, because that's put on the basis that what the court is doing is protecting the ability to enforce a judgment. That's the Australian rationale. And it's because a judgment could be enforceable against somebody against whom you don't have a cause of action that you can sometimes get a freezing order against them. But if you need a cause of action, you couldn't get a freezing order against the Chabra defendant.
Well, with respect, my lord, what I'm trying to suggest is that you need the cause of action against the primary defendant, and Cardilli does no more and no less than recognise that in order to freeze the assets of the third party, they have either got to belong in some sort of way to the principal defendant, or there's got to be some process by which the third party can be compelled itself to give those assets up. Now, that's not the line that's pursued by my learned friend, Mr. McGrath. He puts his claim on the money box basis, if we can characterise it as that. But the right is against the primary defendant, and it's as if the non-cause of action defendant, the Chabra defendant, has become mixed up in the process in some intelligible way. But the court still has to be seized of the proceedings in respect of the initial right. There still has to be a case in respect of the initial right.
Sorry to keep interrupting. But the Australian case, it's the one that I mentioned yesterday, I think we've now been supplied with. It was precisely a situation in which the court had no jurisdiction over the original right. It was a Singapore proceeding, and the freezing order was granted in Australia.
My lord, I'm not sure that my learned friend Mr. McGrath relies on that case.
Well, he may not, but I'm suggesting that it's right.
Well, with no disrespect to your lordship, in an ideal world, I'd prefer to hear what Mr. McGrath says about it and then respond to it. If your lordship insists on me addressing the board now, then
no, not at all. Not if you don't want to.
Well, let me put it briefly. The passages that I took your lordships to in Cardilly yesterday showed the point in my respectful submission, and I have taken the opportunity to ask my learned junior, Mr. MacLeod, who's admitted in Australia as a legal practitioner and is on the roll of the Supreme Court of New South Wales, to explain to me what he understands has been going on. Now, in the passages in Cardilly yesterday, your lordships will have seen that there was an explanation of the English position, and then there was a discussion of the way that Australia seems to have approached things, and there was an attempt to produce a framework for that. And you might have picked up that the High Court of Australia suggested that they should no longer call freezing injunctions freezing injunctions. They should call them freezing orders. And the test was refocused in Australia onto the process of the court, rather than the Lord Justice Cotton line of a subsisting right or entitlement. And that process feeds through into the judgment in PT Bayern and Singapore. And you perhaps see it encapsulated best in paragraph 64 of that judgment. And I'm afraid I don't think this is in the electronic bundles. It's page 17 of the judgment, paragraph 64, and it's the concurring judgment of Justices Neal and Keane. And they say the doctrinal basis of the inherent power of superior courts in Australia to grant a freezing order is not confined to the protection of a pending action or an immediately justiciable cause of action. A superior court has an inherent power to grant a freezing order proleptically to ensure the efficacy of its exercise of judicial power in accordance with the exigencies of its exercise. When it's demonstrated to a superior court that there is a likelihood that its processes will be abused or frustrated, it's within the court's power to make orders considered to be appropriate to prevent that from occurring. So in Australia, by 2015, there's been a complete delinkage of the underlying right from the power. But that's not the approach that has previously been taken in this jurisdiction. In the House of Lords, the Privy Council, or the Supreme Court, and it doesn't seem to have been the position adopted by my learned friend in his skeleton argument, where he endorsed the proposition. I think it's paragraph 64, but I can check. It's at paragraph 46 on page 9178, that he did not argue for any additional jurisdiction. It was the he was saying that it was the practice and power of the courts prior to 1873 that was encapsulated in section 37 or section 24 of the BVI Act. Now, all I can say in answer to your lordship's point is that the courts of Australia have taken a different analytical position on how they wish to make orders. And they have sought to distinguish themselves from the position in England and Wales by no longer calling the orders freezing injunctions, because that goes back to Lord Justice Cotton's observations in North London Railway, and instead call them freezing orders and treat them as a process of, or treat them as part of the protection of the process of the court. That gives the Australian High Court an almost completely unfettered power to grant injunctions, to do anything that it wants, at any point in time, however remote anything might be. The remoteness to the alleged potential misconduct can therefore be extreme. There seem to be very few conceptual limits to the. I beg your lordship's pardon, Lord Briggs.
I was just going to ask you whether you go so to say that that's not an available power within the English context. I'm thinking of the power to restrain the presentation of a winding up petition, which doesn't base itself on any prior cause of action, I don't think, nor even, I think, an equitable duty. It's more to do with preserving the integrity of the court's winding up process from abuse. Around for a very long time, and leads to the grant of what is in effect, whether you call it an order or injunction, injunctive relief.
Well,
say it's now enshrined, I think, in the insolvency rules.
Well,
Yes.
but
it was around long before then.
my lord, yes, and I hesitate to try to embark on an analysis of why that might be on the hoof and without proper knowledge of its history. All I can.
It's just that reading paragraph 64 of Ban, to which you rightly draw our attention, one can hear restraining presentation of winding up petition bells ringing quite loud, as apparently proceeding from a same perception of what the Australian regarded as an inherent power of a superior court record.
My lord, yes. The difficulty is trying to articulate in 2 3/4 hours a comprehensive theory of everything to do with injunctions since the 1600s and the developments of courts of equity. What I try to do is tread a fine line by following through the vesting of the powers of the courts of equity in the Supreme Court of Judicature and the apparently steadfast adherence to the articulation of the principle upon which interlocutory injunctions are granted in North London Railway through the development of the freezing order jurisdiction and the fact that in the context of that development, it has always been done on the basis of the analysis of the position in North London Railway. Now, I quite accept that there are different ways to get to the same answer. Continental Europe, of course, just went for césariat and césar conservatoire. They just identified an asset and injuncted it. And it was based on the location of the asset rather than the claim against the individual. But if it's a claim against an individual, it must be based on, in my respectful submission, on the current analysis of the jurisdiction, on what Lord Justice Cotton said. That has been endorsed again and again, and this is not the case to try to rewrite the entirety of the law of equity.
Can I ask you something, Mr. Morgan, about what Lord Justice Cotton said?
Yes.
The principle that he espoused was that the sole intention of Section 25(8), as it was then, was that where there's a legal right, which was independently of that section capable of being enforced at law or in equity, and whatever may have been the previous practice, the High Court may interfere by injunction to protect that right. Now, what I don't quite understand is why, if there is a future legal right to enforce a judgment in the EVI, the High Court can't interfere to protect that future legal right. You have to add an element of futurity to what he was saying, that he wasn't considering this situation. Why, when you prevent the presentation of a winding up petition, you're not intervening to protect the right not to be wound up on the basis of a non-existent debt? And in almost every case, the same applies. You can frame it in a particular way to an anti-suit injunction and many other kinds of injunctions. What at the moment I don't understand is why Lord Justice Cotton has to be taken as meaning that there has to be an existing right capable of being enforced in our jurisdiction by a separate kind of action. And it just seems to me that it's a very sort of dogmatic construction of what he was saying, and quite unnecessary, actually, and quite unnecessary restriction of the statutory provision.
Well, let me try to answer that. An individual has a right to the use of their property, which, in my respectful submission, they should only be deprived of in the event of somebody else being able to assert a current right to restrict that use. In the present case, CCL has no current right that can be recognised in the Virgin Islands to restrict the right of even Dr. Cho to his shareholding in the BVI. Of course, my attention is focused on Broad Idea. There is no right that's capable of being asserted against Broad Idea that can prevent it from use of its assets. And unless the court has before it an intelligible claim to a right that might impeach my right to my assets, then it can't step in and override my rights to use my assets.
With great respect, Mr. Morgan, that doesn't really answer my question.
I apologise. May I have another go?
The question is that Lord Justice Cotton said that the sole intention of the Section 25(8) was that where there was a legal right capable of being enforced, the court can enforce it by injunction. Yes. And what I'm putting to you is that there is a legal, if there is a legal right to enforce a future judgment, why can the court not step in to protect it by injunction?
Because the future right to a judgment is not based upon any existing right. It's conditional to the point of non-existence. It's not a recognizable judgment. It's not a substantive right. If, and only if, CCL obtains judgment in Hong Kong, it can then come to the BVI and commence a new action against Dr. Cho based on that debt. But that still doesn't get it to the point of being able to say, well, I can get a judgment against Broad Idea. Broad Idea has had no part in Hong Kong. There's been no adjudication by the Hong Kong court that Broad Idea is liable, nor could any judgment of the Hong Kong court be capable of giving rise to a claim in the BVI against Broad Idea, which has not participated, is not a party. There is just no possibility of the Hong Kong action giving rise to a judgment that could be brought to the BVI.
So just to finish on this point, I apologise for sort of talking too much. Put it on the fact that the Act doesn't cover future rights, but that's another very black letter construction of the very broad legislation, and it's certainly not what Lord Dibley was saying.
Well, all I can say is that there is a line of authority ending at least with the Vera Cruz, which is in the bundle somewhere, that says that you can't have a freezing order or an injunction until you have an accrued cause of action. Lord Legate.
Isn't the problem with this analysis that a substantive right is not anyway a right to an asset? Unless it's a proprietary claim, the substantive right is a right to damages, it may be, that you're enforcing in the court. There's an element of futurity anyway, because the freezing order is seeking to protect your ability to enforce a judgment if you get one in the action. So it's all a matter of degree. And if you draw the line like Vera Cruz does, on the basis you can't have a freezing order because the debt isn't due till tomorrow and it's going to instantly be removed, the money, somewhere else, you get into all sorts of unnecessary problems.
Well, my lord, looked at in that way, yes, but the conditionality of the future judgment and its relocation into the Virgin Islands means that one is focusing very much on the existence of the right. But the right is not recognisable in the Virgin Islands at the moment. And indeed, it may not ever become recognisable in the Virgin Islands. The whole point of the enactment, or sorry, of the government of the United Kingdom entering into the Brussels and Lugano conventions, and then Parliament passing the Civil Jurisdiction and Judgments Act, Section 25, was to give the court precisely this power to look to proceedings elsewhere and grant injunctive relief in support of those proceedings. Now, that was a power that, at least to our forebears, was perceived not to exist in the court because of the argument that I'm attempting to articulate, although obviously not very happily. Now, either everybody down to 1998 was wrong, and I picked 1998 because that was the date on which Her Majesty extended the powers under the Civil Jurisdiction and Judgments Act to all proceedings in front of a court in any country, or it was necessary. And if it was necessary, that squares the circle as to why the arguments were right down to that point. That what had been said repeatedly in all of the cases about the requirement for there to be a substantive right before the court would grant a freezing order, substantive right justiciable before the domestic court, even if it wasn't going to be finally tried there, was an essential underpinning to the ability to grant an injunction. was a classic articulation of the pre-1873 position, in my respectful submission. And the fact that Parliament then stepped in and provided an express power to address that point was recognition of that fact. Now, to the modern ear, that might sound slightly restrictive, and I take your lordship's comments that I'm taking a very old-fashioned and analytical approach to the wording, but that was the approach that has been taken or had been taken when these sorts of problems came before the courts. And in seeking to rationalise all of those cases in that line of authority, all of which are set out in Appendix 2 to Broad Ideas written case, I simply seek to draw to the board's attention that that was the way in which it had been done until now. And that is the way in which the Virgin Islands have now addressed the point. The legislature has decided to cloak the Court of the Virgin Islands with an express power to grant injunctions in support of civil proceedings. Now, interestingly, and it may not be a full point, but interestingly, when you look at what the Virgin Islands has done in the Amendment Act, you find at page 13524, you will see that they've given the court the power to grant ancillary relief or to grant interim relief where proceedings have been granted in any foreign jurisdiction. They have done away with the restriction completely. And that follows the approach that was taken in under the 1982 Civil Jurisdiction and Judgments Act in England, as extended by the order. Now, whilst the enactment of Section 25 of the Civil Jurisdiction and Judgments Act in England and the extension of the power to grant injunctions in support of arbitral proceedings removed the power point from the consideration of the English courts, that did not mean that it did not continue to lack such power in the absence of legislative intervention. The ability of the court to exercise jurisdiction over the substantive merits by service of originating process is, in my respectful submission, a necessary prerequisite of the exercise of the power to injunct so as to deprive a litigant of the use of their property. Here there is, I beg your pardon, Lord Leggett.
Do you accept, Mr. Morgan, that the English statute and the Virgin Islands one, it's a much broader power than simply a power to protect a future judgment within the enforcement of a future judgment within the jurisdiction?
My Lord, yes.
You frequently get, or there have been many, worldwide freezing orders granted in England against people who have virtually nothing to do with England, merely just to help foreign jurisdictions who don't have the power to grant freezing orders.
My Lord, indeed.
The case in that line is Haiti and Duvalier. Had no connection with England, but because France didn't have a worldwide freezing order, we very kindly granted one.
Well, my Lord, yes, and it provides endless amusement or employment to academics discussing whether that's the correct approach. But it doesn't require, in effect opens up the courts of a territory to all litigants, wherever they might be, to seek the assistance insofar as they can persuade the domestic court that the grant of the relief is expedient. But it doesn't have to be premised on ultimate enforcement in that jurisdiction.
So that what that shows, doesn't it, that there's still an ample role for this legislation, even if we were to recognise that as a matter of common law or equity, there is the ability to protect the enforcement of a future judgment within the jurisdiction.
May I provide a double-barrelled answer to that? The first part of my double-barrelled answer is that as regards broad idea, none of this makes any difference, because there is no possibility of a judgment against broad idea being granted anywhere, and no case has been articulated that will result in the execution of a judgment against broad idea or its assets. The second part of my answer is perhaps more along the lines of a conservative lawyer saying this is not the case upon which to embark upon a complete rewriting of the circumstances in which the court will or will not grant relief. In my respectful submission, the board should dismiss this appeal against the order against broad idea on the basis of the facts before one even gets into quite how the analysis works. It's going to provide a pretty unhelpful, in my respectful submission, analysis if everything is not decided on the basis of live issues of fact. It will no doubt be welcomed by practitioners because it will mean that we can argue endlessly about quite where the boundaries have now gone. But in my respectful submission, both the Virgin Islands and England and Wales have proceeded for so long on the basis of the analysis of Lord Justice Cotton's statement in North London Railways and its subsequent endorsement again and again at the highest level, that now to, on this case, to say that that analysis was wrong might be unhelpful generally. I do respectfully maintain my position that there is force in what Lord Justice Cotton said, that one is looking for a right that can be asserted before the domestic court. And that once the interest of the court has been excited by a litigant approaching the court with a justiciable claim, then the court can get involved. But it's only then. Domestic courts do not, in the absence of legislation such as Section 25 of the CJJA, the new section in the Amendment Act in the Virgin Islands, courts are not interested in what's going on in front of other courts in other jurisdictions unless and until their process is engaged. So it's not, my Lord Ross. Sorry, the Master of the Rolls.
Sorry, I've got a muting problem. But you're not really engaging with Mr. McGrath's argument, are you? That what he submitted was that the North London Railway, the North London Railway dicta, do not actually justify the decision that he reached, because what he says is you have to look at what the real rationale of the Moreva injunction was. And when you look at what the real rationale for it was, North London Railway provides no answer, because there is a future legal right to likely future enforcement in the jurisdiction. And so if you take the correct rationale for a Moreover injunction, North London Railway doesn't provide an answer, which is what I was putting to you earlier. That actually North London Railway, I mean, of course, if you take it to its logical extreme, you can fit it within the words of North London Railway. But what North London Railway was saying was, you must have a future right to which your injunction is directed. You must have a right to which your injunction is directed. And if we were to say that included a future right, then the real rationale for a Moreover injunction might be enough. And that was the argument that Mr. McGrath addressed. And I don't think that anything you've said thus far, apart from trying to construe North London as being a very tight straitjacket indeed, addresses what he was saying. I mean, he said the reasoning was wrong in the Siskina.
Well, my lord, the future right puts it outside the injunction territory in analysis. But if there is a future right, perhaps the better way of thinking about it is there is a current right to be paid. One way of analysing the Moreover jurisdiction is that there is a current right to be paid. A defendant who comes in and contests that right is engaging with the process of the court and is using the process of the court to obtain time if his defence is unjustified. And it's, in effect, a trade-off. The defendant can't be entitled to run a defence for the purposes of secreting their assets. If there's a current right to be paid, then North London Railway would cover that position. My lord yourself.
Yeah, sorry, it's to pick up on a theme in your submissions that, and you encapsulated it just now by saying the fact it's a future right puts it outside injunction territory. But injunctive relief has always been available on a queer basis, precisely to stop breach of some right that you can see about to happen over the brow of the hill.
My lord, yes.
You have in relation to that is that there be a sufficient intimation now that you can see that there is risk of a future breach of right to justify the court intervening at this stage, but it's still done on a future basis.
My lord, yes, but you have the actual right.
But you may not do, because things might have turned out that in fact there wasn't a breach that was going to occur the way events played out. The court has to make a proleptic judgment, as the High Court of Australia put it. But also, even in a conventional Moreover case, you might not have the right. That's why you have to have the trial to see whether or not you can establish your case. As I think it was Lord Leggett was putting to you, what's enforced in the Moreover case is not the underlying right. It's the prospect that you might get a judgment in your favour. And if that's right, what's the difference between that and the sort of situation we're looking at, where if you get a judgment in Hong Kong, we can see that you can bring that to the BVI, and therefore, subject to all your arguments about it couldn't extend to BI, therefore, if it can extend to someone in the BVI and be enforced against them, why isn't that a sufficient proleptic basis on which XP could intervene?
Well, the right that is being protected is the underlying cause of action that gives rise to damages. It looks forward, it's queer timid, because it says, I've got a right to money and I need it protected for the future. The traditional analysis says that courts are only interested where that right is capable of being asserted before them. At the moment, there is no case capable of being asserted before the courts in the Virgin Islands. And I can't put it any higher or lower than that. The policy question is whether courts should reach out to overseas courts and provide any assistance that's available domestically to those foreign courts, whether asked, whether invited by the foreign court. My Lord Loveloss, Master Ross.
That is, if I may say so, Mr. Morgan, confusing two essential points in this case. The first question is the question under section 2547, whatever it is, whether an injunction is available to protect a future right to enforce a judgment. The second question is as to the territorial reach of domestic courts. And it seems to me anyway, at least, that we must keep those two questions separate. The first question as to the meaning of the statute and what kind of injunction you can grant, whether there needs to be an underlying substantive right before you can grant such an injunction, is the first question. And it's nothing to do with the territorial reach of the court. And the territorial reach of our courts, all common law courts, can surely only be extended beyond the realm by statute. It's not for it's not for judges to extend it. And that's why, certainly for my part, I would have thought that the Siskina can only be justified on the basis that it was the correct construction, if it was, of Order 11 Rule 11I, which gave the court extraterritorial jurisdiction. And if it was right that it didn't cover what was asked for there, then the decision is right. If not, not. But you mustn't confuse the proper construction of the statute giving the court power to grant injunctions domestically with whether or not there is an extraterritorial reach, which is a different question.
My Lord, yes, but if that is, if my learned friend Mr. McGrath's argument is right, then the Siskina is an unnecessary case, because the court could have granted an injunction against the insurance company to restrain it from disposing of assets that would otherwise be available for execution. It could have brought it entirely within the domestic context. The point was that they wanted to, or they needed to find a right that was subsisting within the jurisdiction over which the court had territorial jurisdiction to grant relief, or in respect of which the court had territorial jurisdiction to grant relief. Now, on the first point, your Lordship correctly identifies that there are, your Lordship obviously correctly identifies there are two aspects to this. There's the domestic, or the freezing order part, and there's the overseas foreign jurisdiction part. On the domestic part, the analysis of the freezing order has always been based on the right being the underlying cause of action, and the injunction being granted in protection of the enforcement of the subsequent enforcement of the money judgment. I note your Lordship's displeasure with that.
I'm not displeased at all. I'm not sure that has always been the justification. It's not what Lord Nichols said.
My Lord, yes. It's the majority, it's perhaps I might be brave enough to suggest that it's the more conventional acceptance of the rationale. Again, it's whether that power, the domestic power, is capable of being exercised in support of foreign proceedings where there is no claim domestically. That is my particular focus.
So on your approach, do you have to wait? Do you have to wait until the foreign judgment has been registered in the BVI?
My lord, it can't be registered. Hong Kong is not part of any registration scheme. It can be.
Yeah.
It can be sued on. So CCL can come to the Virgin Islands and say, if it gets judgment, Dr. Cho has got assets in the Virgin Islands. I want to sue on my debt.
Yeah. Yeah.
Your issue is stopped.
Yeah.
And then we're into classic Dyson Morris judgments on foreign proceedings which are not registrable. And one has the normal exceptions. The preferred academic rationalization is not that it's a comity recognizing a foreign judgment, but a court recognizing an issue estoppel between the claimant and the defendant on the underlying right.
Yeah.
But that is only once there is a right that is capable of being adjudicated upon within the jurisdiction. And in my submission, it's the ability of the court to exercise jurisdiction over the substantive merits by the service originating process that's the necessary prerequisite for the exercise of the power to injunct, so as to deprive a litigant of the use of their property. That's the headline point to which I've been attempting to invite your lordships to focus. Here there is no originating process. There's no justiciable right asserted in relation to Broad Idea, its assets or its shares, and in my respectful submission there's therefore no power to grant an injunction. Now, subject to any further questions from your lordships, I was proposing at this stage to move on to my final 2 points. I don't know whether your lordships would like to take a break now or have me start on those points.
It sounds that this is a convenient point. But we'll adjourn now for 5 minutes. Thank you.
I'm grateful.
I think we're ready now to resume. Mr. Morgan.
My lord, yes. So, my lords, my 4th point is that on any view, there's no evidence that Broad Idea's assets ever could be available to satisfy a judgment against Dr. Cho, nor was there evidence of real risk of dissipation by Broad Idea. The Court of Appeal's judgment at page 995 from paragraph 57 was that there was no evidence in support of CCL's case that Broad Idea was a nominee or money box for Dr. Cho, nor was there evidence that its assets were available for execution. That's at paragraph 58. Nor was there evidence that there was a real risk that Broad Idea would dissipate its assets. That's at paragraph 61. Justice Adderley's judgment was not reasoned at first instance, and the Court of Appeal was both entitled and able to consider the identical evidence on the appeal. If it were to have any chance on this appeal, CCL would have to establish that the Court of Appeal was wholly wrong in its assessment of the inadequacy of Justice Adderley's judgment, that it was therefore not entitled to review the facts, and that in conducting that comprehensive and patient page-by-page review of the evidence, it overlooked or failed to give proper weight to a real piece of evidence, by which I mean something that was actually in evidence, as opposed to something that was asserted in CCL's written case was in evidence. CCL has wholly failed to show that the Court of Appeal was wrong, and there is nothing in its oral submissions or its written case that would justify undertaking that task again. Even were the board to have the time to review all the evidence, as is apparent from the detailed line-by-line analysis of CCL's written case, undertaken by Broad Idea in Appendix 1 to its written case from page 9310, the factual assertions made by CCL are either untrue, materially misleading, not in evidence, or not relevant to the notice of application. I have, of course, already shown the board the example of CCL's suggestion that Broad Idea is identified as a company in the Enigma network, and that was at pages 928. 9228 was the assertion, and 3630 was the diagram. But by way of further example of an allegation not being relevant and not being in evidence, CCL uses the word convoy to refer to itself in its written case as early as paragraph 10 on page 9169, although it nowhere defines the term. As a result, a casual reader might be forgiven for assuming that the term is used consistently throughout CCL's written case to refer to CCL. As appears at page 2410, paragraph 6A of Mr. Yap's first affirmation, CCL is an indirect, wholly owned subsidiary of Convoy, which is defined in paragraph 6C of Mr. Yap's first affirmation as Convoy Global Holdings Limited. Now, in reading CCL's written case, by the time the reader gets to paragraph 215, subparagraph 8 on page 9227, Convoy Global Holdings is defined as Convoy Global. On page 9228, paragraph 215, subparagraph 12, it's asserted that the use of Town Health to control Convoy enabled Roy Cho to avoid the disclosure obligations imposed by the Hong Kong Stock Exchange. And there's a reference there to page 3769. This is to paragraphs in the points of claim at 399 of 2018 that do not refer to such control or the Hong Kong Stock Exchange or disclosure obligations. These allegations are also unevidenced as they're not made in any affirmation or any primary documentation of evidential value. However, it's also inconceivable that this could be a reference to CCL, an indirect, wholly owned subsidiary. It must be a reference to Convoy Global Holdings, which is not a party to this application or this appeal. In paragraph, and back to page 9228, paragraph 21514, it's asserted that evidence shows that Town Health traded in and out of Convoy, which may have been determined by a desire to avoid reporting requirements for holding more than 5%. First, as a wholly owned subsidiary, CCL is not traded, so this cannot be a reference to it. Secondly, the reference to paragraph 35 does not begin to show trading in and out of CCL. And insofar as it shows Town Health's interest in Convoy Global, that does not show it as being below the 5% threshold. Thirdly, the paragraphs in 2922 of 2017 to which reference is made, my lord, somebody's dropped off.
We seem to have lost Sir Geoffrey Voss.
I'm here.
Thirdly, the paragraphs in 2922 of 2017 to which reference is made do not even contain these allegations, far less are they evidence of them. They're allegations in a pleading in a different action, not evidenced in this application. Paragraph 21515 then alleges that Broad Idea profited by way of dividends. Again, the cross-references are to pleadings in a different action not relied on before the court that are unevidenced. And when one clicks on the hyperlinks, it shows that even the passages in the pleadings do not make the allegation. And by the time the reader gets to page 9233, paragraph 221, CCL simply asserts the same allegations as fact, when it's plain beyond peradventure that this cannot be an allegation that CCL could ever make. At best, it would be an allegation made by Convoy Global Holdings Limited, but they're not here and there is no evidence. These allegations seem to be made in order to try to raise some suspicion that there might be some sort of unparticularized proprietary claim. However, they do not and cannot support any allegation by CCL to any such claim. The allegations are opaque and undirected and deployed in such a way as to confuse rather than illuminate the position and to be as prejudicial as possible. For the avoidance of doubt, the allegations would still be denied even if they were made by Convoy Global. But it shows that when CCL's allegations are examined forensically, it's apparent that hyperbole has taken over from reality, and what's been written cannot be trusted. The majority of allegations are not in evidence, and they largely don't even relate to CCL's complaints against Dr. Cho, which is evidenced in Mr. Yap's first affirmation from page 2409, relates solely to 3 breaches of fiduciary duty. Further, when Mr. Yap does say something in his affirmations, even that's not to be taken at face value. There are numerous examples, some of which require a lot of page turning and explanation, but that can be achieved given time. However, a quick example is at paragraph 16 on page 2578 of the bundle. And you'll see at the bottom of page 2578, there's a box numbered 3. And in that, Mr. Yap says this. Actually, Francis Choi, in his affirmation in HCA 2922 to 2017, stated clearly that any person could be the guarantor. This is hardly a loan transaction of such substantial amounts reflecting normal commercial terms. Now, actually, the allegation doesn't go anywhere. None of these allegations go anywhere, but most of them have some sort of deficiency. In order to rebut this particular allegation, at page 2571, paragraph 19, Mr. Choi exhibits all of his affidavits in 2922 of 2017. Nowhere in all of those documents does that statement appear. It is simply untrue. Then again, in Mr. Yap's 4th affirmation at page 2587, paragraph 38, he makes a number of assertions about what Mr. Choi has said. Mr. Choi has previously said in Choi 1 at paragraph 15 that Broad Idea acquired an 18.85% interest in Town Health, and gave the clear impression that its interest in Town Health had remained static. Mr. Choi actively misled CCL and the court by failing to explain that Broad Idea had owned over 50% of the total shareholding of Town Health. Mr. Choi was intimately involved in the day-to-day operations of Town Health, and/or Broad Idea interest in Town Health fluctuated since the date of the first investment. The reason for such fluctuation in shareholding is not apparent from the publicly available information. However, page 2495 is what Mr. Choi actually said. Nowhere in that paragraph does Mr. Choi mention 18.5%. It's just not accurate. The money box allegation there that we see repeated only appears at paragraph 48 of CCL's skeleton argument on the ex parte hearing, but not in evidence, nor there's any suggestion that the shareholding remained static or that it fluctuated. And in any event, the whole position is set out in painstaking detail from page 2552 in paragraph 33 of Mr. Choi's second affidavit down to paragraph 56 on page 2557, setting out chapter and verse of absolutely everything that happened with respect to Broad Idea's shareholding in Town Health, and why the number of shares went up and down due to convertible preference share subscriptions, options, bonus shares and consolidation. All of that by reference to public documents. In any event, none of this has anything to do with the claim to an injunction. Again, a full forensic analysis of everything that Mr. Yap says would extend far beyond the time of this appeal, but Broad Idea's position is that it's demonstrable from the primary documentation that Mr. Yap is not a witness of truth. Now, I could go through these allegations in CCL's written case line by line, and as I did before the Court of Appeal, I can invite the Court to consider what's actually in evidence and how it actually relates to the limited case as formally made in CCL's notice of application, but that would be a very lengthy exercise beyond the time allowed for my oral submissions. In order to give a flavour of the deficiencies in CCL's written case, we've provided the Board with Appendix 1 to Broad Ideas' written case, which identifies the more serious inaccuracies, but the Board cannot safely proceed on the basis of CCL's written case. This whole process would have been easier had CCL articulated clearly in a claim form what its case against Broad Idea was. It did not comply with the rules, and the Court has been denied that insight. However, when its chance came in the Court of Appeal to explain its case and what evidence it relied upon, CCL failed to identify any evidence in all this material. The Court of Appeal reached a proper assessment of the absence of evidence, both in relation to the Cardilli test and in relation to risk of dissipation. There's no basis for the Board to reopen that assessment and then itself conduct a further review. Further, the failure to commence a claim that would result in a trial has one further consequence, and that is that CCL's underlying case for its injunction against Broad Idea cannot be tested if the procedure that it has adopted were held to be correct. It will have obtained a permanent injunction on the basis of a good arguable case, and Broad Idea cannot challenge that alleged evidence and whether it's true on the balance of probabilities. My final point is that the Black Swan case and its reasoning cannot stand as good law for the existence of a freestanding so-called Black Swan jurisdiction, whereby the assets of a company are frozen if there's a claim against a shareholder before a foreign court. Now, the Black Swan case is at tab 11 of the authorities bundle from page 9646 to 9654. For the reasons set out in Broad Idea's written case, and on the basis of the analysis of the House of Lords, the Supreme Court and the Privy Council decisions set out, Justice Bannister was wrong to reach the conclusion that he did. However, it's important still to consider the full extent of that judgment. From the title, one can see that the parties are Black Swan and two BVI companies. From paragraph 1, you can see that the underlying fact pattern concerned a claim in South Africa brought against a Mr. Rausenbach, who was alleged to be their owner or controller. And you see that on paragraph 2 on page 2647. One can also see in paragraph 2 that the orders were sought against the companies in relation to their valuable assets. In paragraph 3, one can see that the Court of Appeal granted an injunction over the 6th of January, but there's no transcript of that decision, presumably because it was an ex parte appeal. From paragraphs 4 and 5, one sees the record of the arguments made to Justice Bannister. From that, one can see that although there was argument on the power point, there was no argument on the Chabra point. On page 9650, the judge's analysis is set out. And you can see that he focuses initially on the territorial jurisdiction point at paragraph 7. In paragraph 8, he turns to consider the power point. However, in considering the speech of Lord Scott in Furry and LaRue, Justice Bannister overlooked the first step in Lord Scott's analysis, and that appears in the bundle at page 10605 in paragraph 25 at H. where Lord Scott said this: the power of a judge sitting in the High Court to grant an injunction against a party to proceedings properly served is confirmed by, but does not derive from, Section 37 of the Supreme Court Act 1981 and its statutory predecessors. Justice Bannister therefore assumed that he had the power without addressing the necessary precondition of whether there were proceedings properly served and whether the injunction was granted against a party to those proceedings. That's at page 9651. Then in paragraph 9, Justice Bannister fails to recognise the problem that's clearly before him. The respondents in Black Swan were not defendants in foreign proceedings. They were not defendants in any proceedings at all. Nevertheless, without any further analysis, the judge granted an injunction against the companies. Black Swan has since been taken as authority for the proposition that on a bare application, an applicant can obtain a permanent injunction against the assets of a company in support of proceedings in another jurisdiction against one of its shareholders. Plainly, this decision is wrong and cannot be justified on a proper analysis of the law. It cannot and should not be saved by some sort of carving away of objectionable parts, even were such possible. The board is invited to say clearly and unequivocally that Black Swan is wrong. Were the board to try to save some part of Black Swan by dissecting it, the result would be yet more confusion. The BVI legislature has now passed the Virgin Islands Eastern Caribbean Supreme Court Virgin Islands Amendment Act to give the court the power that it was lacking. Section 3 now confers the relevant power on the court. Such relief may be refused if it's inexpedient, given that the court has no jurisdiction otherwise. If Black Swan is saved somehow, there would be two separate routes by which injunctions could be obtained. One with an express exception where the grant is inexpedient, and the other with no qualifications at all, Black Swan. Further, the impact would not just be in the BVI. Since Black Swan is said to be justified on the basis of the same wording and the same authorities as are relied upon in England, presumably it should be regarded as good law or as a good analysis in England, despite the fact that England has thought it necessary to enact Section 25 of the Civil Jurisdiction and Judgments Act. It would be unexpected if Justice Bannister had discovered a power that no other judge had discerned in England over the preceding 140 years, for which the legislature had then made express provision. He was wrong, and the board is invited to say so to provide certainty going forwards. In all the circumstances, the board is respectfully invited to confirm the decision of the Court of Appeal on the appeal in relation to broad idea and refuse CCL's appeal. Unless I can assist your lordships any further at this stage, those are my submissions.
Thank you very much, Mr. Morgan. We're most grateful to you. We'll turn then next to Mr. David Mumford, Queen's Counsel, on behalf of Dr. Cho.
My lords, I'm most grateful. Can I first check that you can all hear me satisfactorily?
Yes, thank you.
My lords, I should also say I have a slight technical problem in that the image on my screen of Sir Geoffrey Voss is alternating with high frequency with the image of Mr. Morgan, creating a sort of strobe effect. I'll do my best to soldier on, but can I ask that that be looked into by the technical support over the lunch adjournment?
Would it be a good idea for me to leave and come back?
That might fix the problem because it started when your lordship left and came back last time.
Okay, let me leave and come back. Is that any better, Mr. Mumford?
That's much better. Thank you very much.
Sorry it took so long.
My Lords, on the appeal against the judgments of the Court of Appeal and Mr. Justice Adderley in the matter of the application against Dr. Cho, there are two questions. The first is the question which was the subject of both judgments below, which is the scope of the court's territorial jurisdiction, and in particular, on its proper construction, the scope of the service out gateway for claims for an injunction in CPR 7.3. There is also a question as to whether or not the court has power to grant injunctive relief against Dr. Cho at all. That question overlaps with the issue as it arises on Mr. Morgan's appeal, and Mr. Morgan has already addressed the subject in his submissions this morning. Subject to your lordships, I propose to focus my submissions on the territorial question and to deal with that first, that being a matter where I make my own path. But if it's of assistance, I may come back to some points on the power question at the end of my submissions on the territorial one. My Lords, the territorial question raises two questions. And only one of them was addressed by my learned friend, Mr. McGrath. The first question is whether or not this court should be departing from the decisions on the scope of the injunction gateway, as we might call it for convenient shorthand, reached in the Susquehanna and more specifically in the Mercedes. Whatever one makes of the correctness of Lord Dickblock's dicta in the Susquehanna on the question of the power to grant relief, the ratio of the case is, on any view, a decision about the scope of the service out gateway for injunctions. And of course, there's no question but that is also the ratio of the decision in Mercedes. There is some faint suggestion in my learned friend's submissions that actually the true ratio of the decision in Mercedes is not about the gateway, but about the absence of any writ that had a claim for an injunction in it. But if one reads Lord Mustle's speech, it's quite plain that he also dismisses the appeal on the basis of the view that he and the majority of the board reach on the question of the scope of the injunction gateway. Now, our submission below, and it was accepted by both Justice Adderley and the Court of Appeal, was that they constitute, and certainly Mercedes constitutes, a binding precedent on the question that falls before the court on this application, namely whether or not an application for a Moreover injunction, which is inherently provisional and interim in its nature, is the sort of application, the sort of process that falls within the scope of an injunction, the injunction gateway. And that answer was, the answer to that question as formulated in both Susquehanna and the Mercedes, is that the injunction gateways are concerned not with the service of applications of such an ephemeral nature, but with the service of originating process that sets in train some process whereby there is an adjudication of rights. And it is a claim to an injunction as of right that the gateway is concerned with. Now, as I say, the first question has to be on this appeal whether or not there is a reason for the board to depart from those two decisions. It's only if the answer to that question is yes that one gets into the question of what, on the proper interpretation of the rule, is the scope of the injunction gateway. And as I say, the first question is one that my learned friend, Mr. McGrath, did not address your lordships on at all, or at least not make it plain when he was addressing your lordships on the question. But it is a threshold question. We say the Mercedes decision has determined the point. Mr. Justice Adderley agreed with us, so did the Court of Appeal. And we say that unless there is some sufficiently compelling reason to depart from that decision, and likewise Susquehanna, the matter rests there. And it's not in our submission a sufficient reason to depart from those decisions, simply to say that looking at the question de novo, one might come to a different view. All of my learned friend's submissions yesterday were, with respect, submissions that sought to re-argue the construction of the gateway with reference largely to the observations of Lord Nichols in the Mercedes decision. Without disrespect, his submissions amounted to saying that your lordships should prefer the dissent of Lord Nichols on the gateway question to the decision of the advice of the majority in Lord Mustle's speech. That in my submission is not a sufficient basis on which this tribunal can go behind its prior decisions. There must, my Lord Legate.
I took the thrust of his argument, Mr. Mumford, to be that the decision on the gateway was put on the premise of what he says is a wrong understanding of the jurisdictional basis for granting a freezing order at all. And if that basis falls away because he succeeds on the power point, then so too does the rationale for interpreting the rule in the way it was interpreted. That I understood to be his principal argument.
Yes, my lord, but that's, with respect, not a basis for distinguishing or departing from the decision in Mercedes, because the assumption that the board makes, the majority makes, in the advice given by the board there, is that the power exists.
But they were unable to find a rationale for it.
Well, there was an attempt to find a rationale which went as far as identifying that it was sui generis. But in my submission, nothing in their reasoning on the question of the construction of the gateway turns upon the rationale which one chooses to adopt to explain the freezing order jurisdiction. And nothing turns upon the answer that one reaches to the power question. And it's for precisely that reason that the board felt comfortable in approaching the territorial question without deciding the power question. It's not as if this wasn't an issue that wasn't before them. They, of course, had Lord Nichols' dissenting speech. The argument was had before them. Lord Mustle expressly considers in what order he should approach the questions of territorial and power and substantive jurisdiction. He came to the view that the question of territorial jurisdiction could be answered independently and on the assumption that Lord Nichols was right about the power question. And I can take your lordship to the passages, but it's quite clear that the decision is not in any way infected with the Siskina. One might have an argument about whether or not Lord Diplock's construction of the gateway in Siskina can be unpicked from his views on the power question. And one might fairly say of the Siskina that if Lord Diplock is wrong about the power question, then one needs to revisit the construction question. But that cannot be said of the decision of the majority in Mercedes. It's quite emphatically clear that they reasoned to that decision by a different route to Lord Diplock in Siskina. They reasoned to it on the basis of a construction of the language of the rules, read in their context, which doesn't depend upon how one analyzes the nature of a freezing order. Because what's essential to their reasoning is that however one rationalizes a freezing order is inherently something interim and provisional, which involves no adjudication of rights. That's the ratio of the decision in Mercedes. And it's a ratio that's reached on a perfectly orthodox approach to construction of the relevant statutory rule. And it's not a ratio that's affected by whether one rationalizes a freezing order as an order that is granted ancillary to some cause of action or an order that is granted in protection of the court's enforcement process. My lord, if I can just turn to the Mercedes decision, just to make it good that is the basis on which they approach it. There are two passages to look at. The decision starts at page 11738 of the electronic bundle. And the relevant passage starts at 11751, where one sees Lord Mustill identify at letter G the two questions. And the way that he frames the territorial question just below letter G is assume, for this purpose, that Moreover proceedings could have been commenced by writ or other originating process, and assume also that such relief could properly be given, i.e. that notwithstanding the sesquina, Moreover relief in support of foreign proceedings is permissible. In other words, approach the jurisdiction, the territorial jurisdiction question, the question of construction of the gateway, on the footing that sesquina is wrong and that Mr. McGrath is right. And as one can see, he then goes through the analysis in a way that's unaffected by that assumption. What he demonstrates is that that assumption doesn't make a difference to the result. One gets to the main thrust of the analysis at page 11755, starting just below letter F and running on from there. I won't read these passages now, but they are the core of the analysis of why it is that the gateway is to be interpreted in the way that he suggests. And it was a striking feature of my learned friend's submissions yesterday that I don't think he took your lordship to this passage or invited any real analysis of it. We say it is as I say, a perfectly orthodox and rational and indeed well-reasoned approach to the construction of the rule, read in the context of the rule as a whole. And as I say, not dependent upon anything that's in debate on the power issue in this appeal. So as I say, one sees his rationalization or his explanation of the scope of the gateway in that paragraph and the following paragraph, and then he turns at page 11756, letter C, to analyze how his conception of the gateways fits with the language, and one sees that he takes the view that it's borne out by the language of the rules, and there are a number of pointers are highlighted in order 11, which he says support his thesis. We say he's quite right about that, and all of those pointers are equally applicable in the BVI instantiation of the gateway. But just to complete making the point that your lordship asks me about, if one turns over to the end of Lord Mustill's speech, one sees page 11758 from letter G. It may well be that in some future case where there's undoubted personal jurisdiction over the defendant but no substantive proceedings are brought against him in the court, etc., an attempt will be made to obtain a rave relief in support of a claim pursued in a foreign court. If the considerations fully explored in the dissenting judgment of Lord Nichols of Birkenhead were then to prevail, a situation would exist in which the availability of relief otherwise considered permissible and expedient would depend upon the susceptibility of the defendant to personal service. Their lordships believe it would merit the close attention of the rule-making body to consider whether by an enlargement of RSC Order 11, Rule 1.1, a result could be achieved which, for the reasons already stated, is not open on the present form of the rule. So quite explicitly there, he's saying, even if Lord Nichols is right, it's not open to bring that sort of Moreover injunction so conceived within the scope of the rule. So we say that it is incumbent on the learned friend to identify some other compelling reason why the board should depart from its own prior decision on this question. Now, there was some faint suggestion in the course of my learned friend's submissions that there are distinctions between the language of the rule under consideration in Mercedes and the rule as it now appears in 7.3 of the BVI CPR. My lords, that's not a point that was taken below or in the Court of Appeal, the findings of both Justice Adderley and the Court of Appeal were that the rules under consideration in Mercedes and in this case are in materially the same terms for the purposes of the point in issue. There's no appeal against that finding. And my learned friend did not go so far as to articulate why he says any differences in the wordings make a difference to the result. In my submission, the board should regard itself as bound by a prior decision on the construction of a statutory provision, even if that statutory provision arises in a different jurisdiction and is not in identical language, if it's satisfied that there's no material point of distinction between the statutory provisions. That must be right, because if such distinctions as there are between the relevant provisions are not material, then in the interests of the coherence and predictability of the law established by the Privy Council, it ought to reach the same answer. And as I say, my learned friend's not identified why any linguistic differences are material. We would say they're not. They simply reflect the updating of the gateways to accommodate the modern language of claim forms rather than writs. But we'll come to look at the language of the gateway and examine its construction shorn of authority in a moment. And for the moment, my submission is no proper basis has been identified for going behind the Mercedes decision. So far as the question of precedent is concerned, it's not one that my learned friend really gets into in his written case. We in response have not dealt with it at any great length, but I do just draw to your attention that there are a slew of decisions that establish, I say, the proposition that the board is to regard itself as bound by previous decisions on appeal from other jurisdictions. Most particularly, there's the decision of the board in the Bakshoan case. There is also the De La Sala case to which my learned friend, Mr. Morgan, referred this morning. Bakshoan is at, and I don't propose to turn your lordships to these cases now because time is tight, but page 10569 of the record has the Bakshoan decision. That's a case in which there was a question of Mohammedan law, which had been decided in a decision on appeal from the courts of East Africa, and the question was whether the Privy Council was effectively bound by that decision when looking at it on appeal from a decision of the courts of India, held it was. The proposition is also to be found in Lord Manson Turner's book, paragraph 506, page reference 14353. There is also, and I'm not sure whether we mentioned this in our written case, the decision of Lewis and the Attorney General for Jamaica. My lords, that's at page 11520. That is a case that raised a constitutional question about the prerogative of mercy as it applied in Jamaica. And there were prior decisions of the Privy Council in, off the top of my head, I think it was the Bahamas and Trinidad and Tobago. And it was held that those prior decisions were binding and therefore such as the board had to have a good reason to depart from. Notwithstanding in that case that there were differences between the constitutional provisions in all of the relevant jurisdictions. It wasn't a case where one had identical provisions. But the answer given by the board is that unless the distinctions are material, then there's no reason to, one has to treat it as if binding. And finally, that is the view taken by the Court of Appeal of the BVI of the status of Privy Council decisions on appeal from other jurisdictions. And the authority for that is a case called Chastenay, which is in your lordship's bundle at 10262. The only authority that's cast any doubt on the proposition is a Hong Kong case, which my learned friend cites, which is at 9436 of the bundle. Your lordships can read that at their leisure, but in my submission, it misunderstands what de la Sala stands for and Bakshoen and those other cases, and doesn't assist with the analysis at all. So we say unless some material point of distinction between Mercedes and the present case can be drawn, it has to be treated as binding, and one has to identify some compelling reason to depart from it. Now, as I say, my learned friend has not, in my submission, begun to discharge that burden on him. He makes submissions about the attractiveness from a policy perspective of reaching a different view. But in my submission, that can't amount to a reason for departing from the decision, not least because the sorts of policy considerations that were that are invoked in this case, the need for the court to be agile, to prevent lacunae opening up where one's dealing with international fraudsters, were very much present in the minds of the board in the Mercedes decision. They're the very sorts of considerations that Lord Mustle's referring to in the passage I just read to your lordships at the end of his speech. And they're, of course, the very sorts of considerations that play in the dissenting speech of Lord Nichols. But they're rightly regarded as not leading to a different result on the question of construction. Because, quite simply, the very powerful indicators in the language of the rules and the scheme of the rules are not such as to, can't give way to the desirability from a policy perspective of a different result. And that's as true in the Mercedes decision, as true now as it is in the Mercedes decision. My little friend also suggests that one ought to take a different approach now because it is the approach that's been taken in courts of other jurisdictions, that other jurisdictions, to the extent they've not judicially considered the point, have legislated differently, and that the law has moved on. My lord, that in my respectful submission is also wrong and certainly not relevant. Well, this is not a case where, as one sometimes has with issues of departing from prior decisions, where the decision in question, that in Mercedes, has been the subject to subsequent judicial or academic doubt and has had to be artificially distinguished or indeed has not been followed. The Mercedes decision has stood for some 25 years. The only case my learned friend can point to in which it's not been followed is the decision in Crone and Varna, which your lordships were taken to, the Jersey case. And that was followed in subsequent Jersey cases. I'll take your lordship to one of them in a moment. But that's the only instance my learned friend can point to where the courts have taken a different view. And as I'll say, the reasoning in that case is with respect exiguous at best. But in other jurisdictions, the decision has been followed. Thus, for example, it's been followed in the Cayman Islands, in the case of VTB and Malafiev, which your lordships have at page 13151 of the bundle. It's also been followed in Singapore in a case which I'm afraid your lordships don't have in the bundle, but which we did have before the Court of Appeal, a case called Karaha Bodas. So for assistance, I can get your lordships a citation and copy of that case. But Mercedes has been followed in the Singapore as well. To the extent that the point has come up in this jurisdiction, England, it's been regarded as being authoritative. There are two cases that we mention in our written case, which have touched upon the point, a case called Cool Carriers, which is at 10323 of the bundle, and a case which I abbreviate to EEEL, which is at case 10507 of the bundle. It's also right to say that the wider principle established by the Mercedes decision, viz that the gateways are concerned with claims to adjudicate upon rights, with substantive claims, is a principle that has seeped into consideration of other gateways. And so one has decisions in this jurisdiction on the necessary and proper party gateway, where it's been decided that the anchor claim for the necessary and proper party gateway has to be a substantive claim, applying essentially the same reasoning as Lord Mustall does in Mercedes. Those cases, well, we have one of those cases in the bundle, the case of Parbold. If your lordships turn to page, no need to turn now, but if in due course your lordships turn to page 12098 to 9 of the bundle, you'll see the point being considered there with reference to an earlier case called Belletti and Marici, with which your lordships may well be familiar. So Mercedes and its assumed correctness has infected the wider interpretation of the gateways without apparent disapproval. And in our submission, departing from it therefore involves a wider unraveling of the established basis on which one approaches the construction of these statutory rules. So, well, those are my submissions on what I say is the first and the threshold question. Sorry, there's one further point I should perhaps address under the same bracket, although my learned friend didn't really put it this way, but I think he came close to indicating that there's some error of approach in the way that the court undertook its exercise of construction in the Mercedes decision. He, insofar as Lord Mustall had regard to the spirit and not just the letter of the rule, you may recall that expression appearing in Lord Mustall's speech, and it's an expression which derives from earlier authority, including in Rosler and Hilbury. And there has been some controversy recently as to the relevance of spirit to the application of the gateways. I think my learned friend went so far as to say that one shouldn't be looking to the spirit or the presumed intent behind these provisions unless there was some ambiguity in them. We would say that is wrong. It's perfectly legitimate and proper for a court, when construing a statutory rule such as these, to try and ascertain what the intent of Parliament was in enacting the rule. And that is all that Lord Mustall was doing. He was seeking to derive, by looking at the gateway within the four corners of the rule as a whole, within its context, what the intent of Parliament was, what sort of claims, what sort of process was Parliament concerned with when providing these statutory extensions to the court's territorial jurisdiction. And that, as I've said before, is a perfectly orthodox and correct approach to construction. It doesn't involve any impermissible resort to spirit in the sense that it's being considered in some of the more recent cases as being relevant to the discretionary stage of the analysis. Whatever one makes of those subsequent cases, the need to ascertain what the framers of the rule had in mind in the objective sense is, of course, inherent in the exercise of any exercise of construction. So, my lords, we say that one doesn't get off the ground with attempting to construe de novo the gateway. The board is bound by its own prior decision, and that's where the matter rests. If I'm wrong about that, my lord, then I would say that the decision in Mercedes transposed to the BVI version of the rule is plainly the right interpretation of the rule, looked at in its own terms and without reference to authority. Perhaps, my lord.
Can I just ask you, Mr. Munford, forgive me, I can't recollect if it's dealt with somewhere in your case. There are plenty of authorities dealing with the effect of Privy Council judgments as precedent for lower courts. I can't recollect if there is a case which makes it clear what the impact of a judgment is on the board itself.
My Lord, my submission, those were the cases that I was mentioning earlier, and my apologies, I perhaps shouldn't have taken them quite as quickly as I did. But
the Egyptian case, De La Sala and Lewis.
Exactly.
Right. Okay.
Because they're all cases. De La Sala is slightly different because it's considering the status of a previous House of Lords decision.
Yeah.
And its impact on a subsequent Privy Council decision.
Yes. Now, and presumably, if the board is in principle bound by its own precedents, then I take it there would be something analogous to the 1966 practice statement that would enable the board, albeit exceptionally, to depart from its own previous decisions.
Yes, my Lord. There isn't, in fact, a practice direction as such in the case of the Privy Council, but the principles can be derived from various cases. Perhaps most helpfully, one can see them in a case called Gibson, which one can find at page 10704 of the bundles.
Yeah.
Perhaps we might turn to that now. Just take your Lordship straight to the relevant paragraph, because it's not an appeal on similar facts. But the relevant paragraph is paragraph 23.
Yeah. Yes, and there's an important point made that I was going to come to this, that Lord Wilberforce's dictum is a very important one.
Yes, indeed.
Yeah.
And we say, we draw out, first of all, the reference to the use of the practice of departing sparingly, and the identification of considerations such as whether the previous decision is thought to be impeding the proper development of the law.
Yes. So in other words, I mean, implication of what's being said there and by Lord Reed in the passage quoted in the next paragraph is that it's not enough that we think that the board got it wrong on a previous occasion.
Exactly.
Yeah.
My Lord Briggs.
In Lord Mance's book, in the passage which somebody's put in the bundle, starting at page 14354, by reference to Gibson, but a lot of other authorities as well.
Yes. Yes, it is. I think we put that in the bundle. It's summarized there as well. Yes.
Yep. Thank you very much.
So, my lords, I was going to turn to the rule itself, which is to be found with some files at page 13566 of the electronic bundle. And I draw out, looking at the rule, the following points.
Can you just give us a date?
A date?
Yes.
I think this was originally enacted in 2000.
Thank you.
There have been amendments since, but not, I think, relevant to the issues on this appeal. My Lords, one sees that it's 7.1, the rules introduced by saying that this part contains provisions about the circumstances in which court process may be served out of the jurisdiction. And two, there is a defining of what is meant by references in the part to the service or filing copies of the claim form. And it's said that that includes certain other documents that need to be served with claim forms under other rules. But there's nothing in there to suggest the claim form is having anything other than its ordinary meaning. Claim form, my Lords, is a term that is defined in the rules. If one turns back to Rule 2.4, which one finds at page 13561. At the top of the page, one sees claim form is to be construed in accordance with Part 8. And one sees also, importantly, claim is to be construed in accordance with Part 8. And Part 8, my Lords, is the provision to which I think you were taken in the course of submissions yesterday, which sets out how to start proceedings and provides for various types of claim form by which one initiates proceedings. And it's within that part that one finds the rule that Mr. McGrath took you to yesterday that says that where you are seeking relief in relation to proceedings taking place abroad, you do not use a claim form. You make an application under Part 11. Well, Lords, that's you can see that at 13577 in case you want to go to it again. Sub-rule 6 of Rule 8.1. But going back to Part 7 at 13567, one sees in Rule 7.2 a claim form may be served out of the jurisdiction only if, it's Rule 7.3 allows and the court gives permission. And then one has the gateway set out in 7.3. The court may permit a claim form to be served out of the jurisdiction if the proceedings are listed in this rule. Rule 2 is the one with which we're concerned, and it starts: a claim form may be served out of the jurisdiction if a claim is made. And we say those are clearly references to a claim form and claim as defined. In other words, references to what one does through the initiation of process under what in the BVI is Part 8, what we would call Part 7. Claims are such claims as one would make in a claim form, and a claim form is the document by which one initiates the adjudication of substantive rights. My Lord Legate.
It's a little while since I've dealt with applications for relief under our own Civil Judgments and Justice Act for in relation to foreign proceedings, but I believe you need to have a claim form to initiate such an application for an injunction in England, don't you? If you're relying on, if you're seeking an injunction in aid of foreign proceedings under the statutory provision, it doesn't dispense with the need for a claim form, albeit that there's no substantive claim in England.
You do need to have a claim form, or at least that is the practice. Certainly that is the practice in the commercial court. I think what the practice in other divisions may be, I confess I don't know, but certainly the commercial court guide says that one should have a claim form, but it's a Part 8 claim form, not Part 7. And I mean, one of the difficulties with the BVI rule is that Part 8 claim, the equivalent of our Part 8 claim forms, which are fixed date claim forms under their Part 8, confusingly enough, You can see this at page 13577, confined to certain specific sorts of proceedings. Subrule 5 on page 13577 at the top of the page. Fixed date claim forms must be used in those 4 situations. There isn't an obvious provision within the BVI rules whereby one could start the equivalent of a Section 25 application by claim form. Your Lordship's right, it is how it's dealt with in our jurisdiction, but of course, our jurisdiction has legislated for this power, and it has also legislated for there to be a gateway specifically applicable to the exercise of this power. Practice Direction 6B, paragraph 3.1, subrule 5 is a specific gateway created by enactment for the service out of applications for relief under Section 25.
Thank you.
My Lord, going back to page 13567, one sees, as I said, a claim form may be served out of the jurisdiction if a claim is made, and one has the keywords for an injunction ordering the defendant to do or refrain from doing some act within the jurisdiction. And we'll come back to that, my Lord. But just to note, if one flicks forward through the other gateways, one sees the formula of a claim form may be served if a claim is made in relation to all or almost all of the other heads. And they are, of course, we would say all heads that are concerned with substantive final relief in the nature of something to which one might meaningfully say one has a right. My learned friend made the submission yesterday. Well, those are the cause of action gateways, but the gateway we're concerned is different. It's a relief gateway. That may be right, but that's not the point I make. The point I make is that one gets the flavour of what the relief gateway is concerned with from the fact that the same language is used in relation to what are quite clearly cause of action gateways. My Lord Briggs.
Could you just help me, Mr. Miller? But if one is seeking a freezing order in the BVI, before necessarily, I think or at least ordinarily, before proceedings have been started, and it's a case where, let's suppose, there's the substantive proceedings would have an obvious gateway under the rules for the service of a claim form, but you first want to get and then serve a freezing order. What is the gateway under which the order which you get under Rule 8.16 A can then be served out of the jurisdiction?
Well, I think it's probably Rule 714, which you find at page 13575.
Thank you.
And that's the provision that deals with orders and applications. Now,
that doesn't, 714.1 doesn't quite cover where you make your application before the proceedings have been started, does it?
It doesn't. There is a case in the bundles of the BVI Court of Appeal called Halliwell, which I can give you the reference to. I have it in my notes here. It's at page 10910, which, although not considering specifically this situation, says that rule is to be interpreted as applying not necessarily requiring that you have to have already obtained permission for the service out of the claim form, but that the proceedings in which you make your application have to be such as you could obtain permission for service out of the claim form. So I think the answer is that provided that one's undertaking to issue and serve out a claim form for a substantive claim under a substantive claim under one of the other gateways, then there's a jurisdiction under 714(1) to permit the service out of the application and the order, even if you haven't yet obtained.
Can you just give me the page number for Halliwell again?
Yes, it's 10910.
Thank you.
Well, that's the relevant passage. But the important point in that case, and indeed,
can I just ask a short follow-up question?
Yes.
Do I take it from this analysis and from Halliwell that an application of a type which wouldn't be followed up with by a claim form, such as for a Norwich Pharmacal order or something similar, wouldn't have any provision in the rules that enabled it to be served out of the jurisdiction?
I think that's probably right, my lord. Yes, I think that's probably right.
Yes, thank you.
I mean, it's probably fair to say that I'm not sure that's necessarily a problem, my lord, because one must bear in mind that one's concerned here with the BVI, and it's not immediately obvious why one would be coming to the BVI to seek Norwich Pharmacal relief against a foreign respondent to the BVI, unless there were some proceedings on foot in the BVI. There it is. Turning back to Rule 7.3, page 13567 and following, as I say, your lordships have, I hope, my point that one gets the flavour of what the gateways are concerned with from the cause of action heads, which use the same language as of claim form and claim is made, as one gets in sub-rule 2, that with which we're concerned. The next point, my lords, turning forward through the rule, is that 7.5, 1B, page 13570, one has to attest 7.51B that the claim, in the deponent's belief, the claimant has a claim with a realistic prospect of success. In our submission, that tells one something about the nature of the claims that the gateways are concerned with. I'll come back to a point my learned friend makes on that point shortly, but I ask your lordships just to note that. And fifth, one sees in 7.52 that the order granting permission to serve out has to contain provision for an acknowledgement of service and for a defence. And likewise 7.6, the claim form has to state the period within which acknowledgement, service and defence would be filed. So, and then, sorry, finally, one you already have my point that there is a separate rule that deals with applications, 714. So we say, stepping back, it's quite clear that much like Order 11, as considered in the Mercedes case, these rules are directed at claims which are commenced by a claim form or writ in the old language, which could lead to a judgment in default of filing a defence, in other words, which compel you to enter an appearance or suffer judgment, and which one could meaningfully be described as having a real prospect of success. And we say an application for a freezing order is not of such a nature. and my learned friend says, well, that's just bare assertion. Well, it's not bare assertion that that's what the rules require. It's an assertion that emerges from a construction of the rules as a whole, as I hope I've demonstrated. It's also not an irrational interpretation of the rules. It's perfectly intelligible and coherent in my submission. The legislature should have decided that territorial jurisdiction should be allocated on the basis that there are substantive claims which the BVI court is being invited to adjudicate upon, and that a claim of an inherently temporary nature, an application, it founds an insufficiently cogent link to the jurisdiction for the court's extraterritorial powers to be exercised. As I say, a freezing order can't readily, or indeed at all, be brought within the scheme of the rules as appears from those indicators. The first point, my lord, which I might just make briefly before we rise for the short adjournment, is that, of course, in this case, there is no claim form against Dr. Cho. Nor, we would say, even if there could be a claim form, would there be a claim in the sense that the rule defines it. As I've pointed to, it appears that the BVI rules envisage that one cannot seek a freezing order by way of claim form when it's not ancillary to some substantive proceedings before the court. I don't understand my learned friend to dispute that proposition. He, in fact, urges upon your lordships that he's compelled to proceed by application notice. But that's not an answer to the point. That there is no claim form, and the rules envisage that there has to be for process to be initiated against a foreign respondent. What my learned friend says is, well, this is just a procedural slip and it can be corrected. But with all due respect, that is to miss the point entirely. He points to the power under CPR 29.6 to correct procedural errors. If you'll note, that's at page 13606 of the bundle. But there's no application before the Privy Council for the correction of such a slip, nor was there below. But in any event, it's not on point. The point we make is that Rule 7.3 is concerned with the service of originating process in the form of a claim form. That's how one founds jurisdiction against a foreign respondent, and one can't do it by an application notice. That's not an error of procedure, or it's not an error of procedure that can simply be cured. It's a failure to serve the very process that's required for the court to have jurisdiction over Dr. Cho at all. Now, my learned friend made reference to a decision of Mr. Justice Jack in a case called Great Panorama at page 14539 of the bundle. Perhaps I might turn that up very briefly.
Well, if we're going to be looking at a new authority, Mr. Mumford, I wonder if we might return to that after the short adjournment.
Certainly, madam.
Very well, we'll adjourn now and resume at 2 o'clock. Thank you very much.